Hello everybody, this is Soumya Santosh, a CMA finalist. From today onwards, we are going to start our corporate and economic law classes for CA final and CMA final. So, I have decided to take the topic of director. So, we are going for the chapter appointment and qualification of director. When we go for this chapter, the very first question came in our mind is, why is there need of directors in the company? Very first thing came to our mind is there any need of director in the company when there are members in the company, right? So actually there is a very big need of director in the company. We are going to read that why. As we all know that the company is an artificial person, right? Is incapable of acting by itself. Company can't move, right? So the decision making should be done by any of responsible person, right? Who is literate, who have experience, who have knowledge and skills, and so on, so on, right? So either that could be our member or director, right? Members. So again, company act through by two, which is director and board of directors and member, right? Still, when they are members, then why is need of director, right? Okay, let's read out. Directors are accountable to members in as much as members are empowered to appoint and remove them. Actually, members are having power to appoint the director, okay, and they are also having the power to remove the director. If any of the director go against law or violates any law, then they have fully right to remove the director from their respective office, so and so on, okay. Now, separation of ownership from the management. Actually, members have no inherited right to participate in the management, okay. And specialized body of person directors are appointed by the member. Again, they are saying this thing. Why they are saying this thing? I'll tell you. If any of default is done by any person, right? For example, there are approx 1,000 members in one company, okay, and company want to take a quick decision. So tell me, is it possible to take a quick decision in a day? Okay, in a day by 1,000 of people? When there are 1,000 of people, there would be 1,000 of opinion, right? Each person is going to give their opinion, and everybody's opinion do matter, right? They are going to differ from person to person, right? So what? It is not possible that we are going to listen to each and everybody, right? And one person, the director should be responsible for everything. He should be capable, he should have experience, he should have knowledge, and related to field and out of field sometimes, right? So sometimes, and one more thing, each and every member are not literate, right? Some might be literate, some might not be literate. Some might have experience, some might not have experience, right? So that's why opinion person to person really matters, okay. This is one of the reason why we actually need director in the company, okay. And one more thing, what happens when any default is done by any of the officer? Who is going to be responsible in any of such condition? If such condition do arise in future, so one person should be held responsible for such default, okay. So in this case, the company will scold whom? Director would be responsible for such fault or default done by any of person, right? Because major decision is ultimately taken by directors, okay. Now the third point says about the statutory requirement to have the directors. Act has recognized the need for the directors, and it requires every company to have BOD, board of directors. for such as for public company the minimum number of directors, for there are minimum number of directors for every company. For public company it is 3, minimum number of directors should be 3. For private company that is 2, and for one person company as name that is only 1. Is it clear everyone? Okay, so we are going to the next point. Hope this part is clear. This is the actual reason that we need director. Okay, we are going for the next part. We know what is executive director and what is non-executive director. Let me give the definition of executive director. The one who is in employment with the company, right? The full-time director, the whole-time director, managing director, right? So what would be non-executive director? Opposite of this word, this sentence what I said, right? They are not in employment of the company, right? Executive director are those who are in employment of the company, and non-executive director are those who are not in employment of the company, right? Actually, executive directors are active. They take active and participate in day-to-day affair of the company. They know well about the activities, what are actually happening in the company, right? Because they are there fully, right? They are full-time workers. Okay, but what about the non-executive director? You may also know them as part-time directors. Okay, for example, nominee director and professional director are the non-executive director. Acha, do you know nominee director? Hope you know. Okay, let's move to the next part. The section 166, which says about the duties of director. Do you know what are the duties of director? Duties of director is to act as per article. Okay, they have to act, they shall act in accordance with the article of the company. Is it clear? The very first point is very simple. I'm not going in depth of these points. Okay, second, they have to act in good faith, right? What is that? They have to promote the objective of the company. Not that the director have to promote his own objective. The director's main role, the main objective is to promote the company's objective, right? And third point is to duty to exercise due care, which is they shall exercise his duty with due reasonable care, skill and diligence. Okay, again, fourth is to not to make any undue gain, which is he shall be liable to pay to the company. Again, he should not take any advantage from, or is going to make any advantage or getting some undue gain from any of the activities in name of company. Okay, if he have done or is engaged in any of the activities, so what is going to happen? In such case, he shall be liable to pay the equal amount the gain arise to the company. Okay, whatever the gain, undue gain is arised by the director on behalf of company, the equal amount is to be paid by director to the company. Is it okay? Is it clear? Okay, now fifth point is about that he shall not assign his office. It should not be like that the director have some work, like he want to go for out, okay, and he is giving his office to his colleague or his friend of him, okay, and he's saying that come to my office and you have to handle my office for 4 to 5 hours. Okay, it's not going to be happen. In actual case, it's not going to happen. Okay, so if he have done any of act, in such case, such assignment shall be void. Is it clear, everyone? Okay, 6 points is about the duty to avoid conflict interest. He should not avoid conflict of interest, which means shall not get any involved in any of the situation. Is it clear? Now, if he go against the duties of director, or he have gone for the contravention, in such case, he will be punishable with fine. How much? 1 lakh, and which could be extended up to 5 lakh. Okay. Again, he would be punishable with fine of rupees 1 lakh, which could be extended up to 5 lakh. Okay, the fine is not going to be less than 1 lakh. Okay, so these were the actually very easy point. I really don't want to get into this point very deep. Okay, hope this was very much clear to you. Okay, let's jump into the next and one of the important topic. What is DIN, Director Identification Number? Do you know? Is there any need of Director Identification Number? Every director is mandatory to have DIN. Okay, now let's go. For the section 152 says that mandatory to have DIN. Why is there any mandatory? Is there any mandatory to have DIN? Yes, I told you yes. Okay, let's go and find out why. Okay, no person. Law says that no person shall appoint as director of company unless he has been allotted what? He has been allotted DIN. Okay, and 152 says about mandatory of DIN. Okay, remember section. Possible, try to quote quotations, section name, section with topic, right? You have to remember each and every section. Try to at least remember the important, important section. Okay, now we are going for the next section, which is section 153, which says about the application of DIN. Do you know we have to file application to whom for DIN? We have to file an application to comment below. Right, I'll tell you. Individual intending to be appointed as director. Right, the individual who is intended to be appointed as director shall make an application. Application to whom? To central government. To whom? Central government. Just a second. Okay, to whom? To central government. Is it clear? In which manner? In such a manner, such form and manner, with such fees which is prescribed in the law. We know this line very well, right? In such form and manner with prescribed fees, which means 152 says, section 152 says about that there is mandatory to have DIN number first. 153 says about the application of DIN is made to whom? To whom? To central government. This is made to central government in prescribed form and manners. Okay, with prescribed fees, whatever the written in law. Okay, now 154 says about the allotment of DIN. Do you know central government allot DIN? Yes, I know this. Okay, central government allot DIN applicant within how much days? Within 1 month, right? Central government allot DIN to applicant within 1 month. From now, you have to tell me that from 1 month, I'm going to take 1 month from which date? From receipt of application of allotment of DIN. Again, 1 month from receipt of application, right? Which receipt of application? This part. I'm talking about this part. When I send application to central government, for example, I am director and I have sent application to central government, right? When the central government receive the application, the 30 days, 1 month would be counted from the date when central government received the application by me, right? By this person, by director. Is it clear, everybody? Hope this is clear, right? Again, section 152 says about the mandatory to have DIN. 153 says about the application to whom. 154 allotment. Okay. 155. Section 155 says about the prohibition to obtain more than one DIN. Is it possible that one director is getting 4 or 5 DIN? No, that would be void. That is prohibited as per law, and no director can appoint more than one DIN. Is it clear? Yes, hope this part was also clear. Now let's move to the next part. 156. Intimation of DIN by the director to the company. Which means, again I'm saying 156 says about the intimation of DIN by director to the company. Okay, let's go for this. The director who receive what? Who receive allotment from central government. Okay, have to intimate his DIN number to the company. Okay, but there is also time limit that he have to intimate that DIN to the company within 1 month of receipt of DIN. Is it clear? Let me tell you again. Okay? Once the person got allotment of DIN by the central government. What I said that the central government have to allot within 1 month of receipt or application of allotment. Right? I'll give example later. Okay, but let me make a clear version of this sentence. Okay, so central government will make an allotment of from receipt of application of allotment of DIN by the person, me. Okay, now once the allotment is done by central government, for example it was done on 7th, let's take the rough example, 7th of August, right? From 7th of August, what is my duty? I'm a director of company. I have to inform company, right? I have to inform company that I got DIN, right? DIN by the central government. Within 30 days of receipt of DIN, I have to inform it to company. Is it clear, everybody? Hope this one is also clear. Again, 152 says about the mandatory, 153 says about application, 154 says about allotment, 155 says about prohibition of not to obtain more than one DIN, 156 tell about the intimation of DIN by director to the company. It should be done within 1 month of receipt of DIN. Is it clear? Yes, it's clear. Now, another important thing that 157 is also intimation of DIN by company to registrar. Earlier it was 156 was about the person the director have to intimate it to the company, right? Is it clear? Now the company have to intimate to the third person. Who is third person? Registrar. They are interrelated person, okay? They are not third person, but they have to inform to registrar, right? Within how much days? Now the question comes here is within how much days? Let's go for the thing. Intimation by company to registrar should be given within 15 days of receipt of intimation of 156. Got it? What did I say? That the intimation by the company. What? I have given intimation to company. Right? Again, I have given intimation to company. I have given intimation on 7th of August. Okay? And 7th of August to the company. Right? So, company is responsible to give within 15 days, from 7th to 15 days to the registrar. Is it okay? If the company is unable to do so, so what is going to happen if company fails, right? Company is liable to pay the penalty of rupees 25,000. Okay, what is company have to do? Company will pay the penalty of rupees 25,000. Again, every officer will also pay rupees 25,000 who was in default, right? Who was in default would be liable to pay rupees 25,000 until they will have to pay if the failure is continued, right? If that failure is continued, okay? But how much if still it's continuing, then how much they have to pay the fine? First of all, what I said that 25,000 is the fixed amount they have to pay. Once they have not intimated the registrar, the company have not intimated the registrar, they have to pay how much amount? 25,000. This is the fixed amount. Okay. Now, how much if If the failure is continuing, in that case, further penalty of ₹100 for each day, ठीक है, for each day is to be paid, subject to the maximum of 1 lakh rupee. What I said that 100 rupees per day, okay, but maximum up to how much? 1 lakh rupees. Not more than 1 lakh rupees would be accepted. Okay, is it clear? Now, section 156 was about, and 157 was about, okay, 158 is about obligation to indicate DIN. Now, every director who have allotted DIN number, DIN, have to write his DIN in written information, particular each and everything. Okay, this was a very simple and easy thing. Okay, now again, point A, section 159 says about the penalty for default of certain provision, right? If any individual or director make default, okay, if any individual or director make default under section 152, 152 was for mandatory, right? 155, हाँ, tell me, जल्दी prohibition है क्या? 156 is about intimation, right? If any individual and director made default in these three section, which is 152, 155 and 156, in such case they would be liable to pay penalty of ₹50,000. And such failure continues, if such failure continues for each day, they will pay for 500 rupees for per day. Is it clear, everyone? Is it clear? Chalo, hope this part was also clear. Again, I'll give you example, but before I have to, let's remember the section, right? 152 says about the mandatory or to have DIN. Yes. 153 says about the application for DIN. Yes. 154 says about the allotment for DIN. 155 says about the prohibition to obtain more than one DIN. Right. 156 says about the intimation by director to company within 30 days. Is it? Yes. 157 says about the intimation by company to registrar. Is it fine? Yes. Now what was 158? 158 was again about obligation to indicate DIN. Is it clear? And 159 was again about penalty for default of certain provision. Is it clear? Hope this was clear. Okay. Shall I give an example to make it more clearer? Huh? Chalo, let's go for one example in that case. What I said that the central government, for example, this is X, right? X have allotted on 1st of January, right? Have applied for application. To whom? Central government. What I said, within 1 month, the central government have to allot him DIN. Is it right? Yes. So within 1 month, central government have allotted the DIN number to Mr. X. Right? So suppose he have given him on 30th of January. Mr. X got his DIN on 30th January. Is it clear, everybody? Hope this part is clear. Okay. Now, do Mr. X have any responsibility that he have to intimate his DIN to company? Yes. From this January 30 to next 30 month means 1 month. Right? He have to intimate the DIN to whom? To company. Right? Suppose he is very disciplined person and he intimated to the company on 30th January itself. Okay? So, on 30th January, the company got his DIN number, Mr. X DIN number. Okay, now is it that the company have to intimate his DIN number, Mr. X DIN number, to anybody else? Yes, the company have to intimate Mr. X DIN number to registrar. But what is the time limit? Within 15 days. But from when? But from when? Again. But from when? Receipt of intimation under section 156 and receipt of, which means he have to tell within 15 days. 15 days from when? Receipt of intimation under section 156. Comment below. I'm not going to tell you now. Okay. Hope this part was clear. If you have any doubt, please ask me. Okay. Next part. Let's go for the next part. Again, this is very easy. The section comes qualification and this is disqualification. Sorry, his qualification not. This is disqualification of director under section 164, which says about, these are very simple disqualification points and we are reading them from intermediate. Okay, so I'm not going into depth of these points and this would be very clearer to you. Okay, so again, let's go for that. If someone is unsound person, okay, again, due to undischarged insolvency, if he is, again, the person is undischarged insolvent. Okay, again, third point was applying to adjudicating insolvent and spend application is pending. We know this point also. Fourth, convicted by court and involving moral turpitude or otherwise sentenced to imprisonment for 6 months or more and 5 years had not elapsed from the date of expiry of sentence. Hope this is also cleared. Okay, an order passed by court or tribunal. Is this also clear? Hope this was also clear. Okay, or not paid any call on shares. There is one more thing, that he have not paid any call on shares. With that, the one condition that 6 months have elapsed. Okay, 6 months have gone, which was fixed for the payment of call. Right? He have not paid call on due date and 6 months have elapsed from the date which was fixed for the payment of call. Is it clear, everyone? Yeah, hope. And next point was of offense in dealing with related party transaction under section 188. Again, we'll go, but just reminding the point that the point says that when is the person disqualified, right? The person would be disqualified when he is of unsound mind, right? Undischarged insolvent, when he has applied to be adjudicated insolvent and or spend application, his application is pending actually. Okay. Next, convicted by court. If he is convicted by court, and there was also one more thing, which means if he was convicted by court plus he was imprisonment for at least 6 months. If he was imprisonment for only for 2 months, then in that case he is not disqualified. Simple. Or 5 years have not elapsed from the date of expiry of sentence. Right? If 5 years, once he got imprisonment, 5 years is not elapsed, in that case he will be disqualified. Right? If this condition is fulfilled, which means he is not disqualified, otherwise he is disqualified. Okay, or any order is passed by tribunal, then we can't do anything. Again, shares call are not paid by him on maturity time. Okay, and 6 months are elapsed again, right? In such case, and in case of related party transaction under section 188, right? This was on behalf of a person, right? An individual. But what if the company make default, right? There are some few points we have to remember, and they are: if the company do not file the financial statement and annual return for continuous period of 3 months, In such case, there would be disqualification by reason of default made by company under section 104 subsection 2. Remember, the section 164 subsection 2 says that if the company have not filed financial statement and annual return for continuous period of 3 months, exactly, for continuous period of 3 months, is it mean that for year 1819, 1920 and 2021, for example, he have not paid on 1819, 1920, and he have paid the annual return for 2021. In that case, he will be not disqualified, right? And again, for fourth year, he have not paid the annual return. Okay, which means the law is saying there should be a consistent period. Okay, there should be a consistent period. There should be a continuous period of non-filing. Okay, of non-filing of either financial statement or annual return. So what is the section of financial statement? 137. 137 says is the section for financial statement. Okay, for the annual return 92. Okay, so this was one of the condition. Or there is another condition which says that if there are two conditions. First condition, if the company is unable to pay annual return financial statement for a continuous period of 3 financial year, right? This was one of the reason. And second reason was if company has failed to repay the deposit. Again, repay the deposit. Okay, redeem any debenture. Again, redeem any debenture or pay the declared dividend. What? Or pay the declared dividend. Okay, and such failure continues for 1 year or more. Again, I'm going to say the second default, if the company is unable to pay, say it with me, repay the deposit. If the company is unable to repay the deposit on time, definitely. Okay. Next, second is redeem any debenture. They have failed to redeem any debenture, right? Or unable to pay, unable to declare the dividend. In these three cases, right? And still the failure continues for 1 year. If it is continuing for 1 year or more, then only they would be held responsible as disqualification by reason of default made by company under section 164 subsection 2. Is it clear, everyone? So hope this topic was clear to you. So we were up to this topic. Today's topic was up to this. Hope topic were clear to you, and we'll meet tomorrow. I'll keep updating and uploading, keep a continuous video on this channel. So please stay updated. Till then, bye. This is Soumya Santosh.